Hey guys, today we are going to talk about further and better particulars. Some of you may have watched the previous video I did on drafting of pleadings and importance of particulars. But what happens if the particulars are inadequate? Well, different lawyers have different styles of lawyering. For me, I like to look through the pleadings, the court documents, look for holes in the pleadings to see if there are any allegations in the statement of claim or the defense where they do not provide adequate particulars, and I like to ask for further and better particulars. When inadequate particulars are provided in the pleadings, the court documents, the other lawyer can request for further and better particulars by letter. This is what a letter for further and better particulars looks like. Now, when the lawyer receives a request for further and better particulars by letter, he has to provide the particulars under the court form called particulars served pursuant to the request. This is what it looks like. Now, it is very important when asking for further and better particulars to phrase the question as how, what. Please provide full particulars of this. How is it? How did something happen? What did the defendant do? Never ever phrase the question in a further and better particulars. Why? Do not say why did the defendant or why did the plaintiff not do this or that. The court is unlikely to grant an order for further and better particulars if the question is phrased that way. What happens if you receive a request for further and better particulars? My advice to my clients is to always comply and provide the particulars. But a lot of lawyers, they like to be 怪懒, okay? That means naughty. They like to be naughty by refusing to provide the further and better particulars, and their reasons are, for example, the requested further and better particulars are irrelevant or necessary. This is how it looks like. Another reason that the lawyer can provide is that it is a matter of evidence, or the particulars requested are of the nature of interrogatories. Let me show you what these reasons look like. So, what happens if you are faced, if you request for further and better particulars and the other lawyer refuses to provide them? It's very simple. Just take out a court application called a summons for further and better particulars, and the judge during the hearing will hear arguments for both sides, why they are necessary for the pleadings and why they are not of the nature of interrogatories, why they are not a matter of evidence. And then the judge, depending on how the request is phrased, may grant the order for the other party to provide further and better particulars. Let me show you an example of a request for further and better particulars by letter, which I took out because the opposing lawyer stated in the statement of claim that the profits were not as high as what the defendant claimed. That's all he stated. He did not provide particulars of how high the amount, the quantum of profits that were claimed. He did not provide how the claim was made, whether orally or in writing, when it was made. As you can see, the paragraph in the statement of claim simply states the profits were not as high as what the defendant claimed. So these were the questions I had to ask to provide particulars for. How much profits did the defendant claim? When was the claim made? Was it made orally or in writing? If in writing, which document? If orally, please provide the date and time. So the take home for today, it is always important to provide particulars in your drafting, and when the other party requests for further and better particulars, it is always advisable to provide them unless for some reason you cannot or you don't want to. So thanks for watching this video. Don't forget